This opening feels casual, but don't be misled. The courtroom is already in motion. Even small remarks here suggest that plea discussions may have been decided behind the scenes.
It'll be dismissed probably. I guess I don't know what we're pleading to, so they're all initials. All right. Thank you.
I need 2 seconds from Mr. Schmidt. He was only in jail 2 days. He doesn't remember how many days he spent before. On the 9th? In the 9th, out of the 10th?
Mm-hmm. Oh, well, 2 days is enough.
2 days, and he has 250 posted. We have a lot of cases. Who to do this case? Yeah. Okay. Somebody can just tell me how much he has posted, because 15 would have been done.
Yep. Per minute here.
I did not forfeit back in 2020. I thought it was going to come back. Yeah, that's what I'm seeing too. So, okay. So Amy may she's coming. I can go slow. That's fine. We'll just do it. We'll go on the record in the matters. 15 CT 67, 15 TR 997, 20 CT 47, 26 CT 14. State of Wisconsin versus Michael Glinke. The state appears through District Attorney Kevin Schmidt in person. We have Mr. Glinke in person with his counsel, Eugene Harrington. We're set today.
Now we officially move into the case phase. Multiple charges, multiple case numbers. This isn't just a single mistake. The court is addressing a pattern of behavior.
In these matters for initial appearances, Mr. Harrington, the parties have reached an agreement. Can you please recite the agreement for the record?
Defendant will plead guilty to 26 CT 14, 15 CT 67, and 20 CT 47 to be dismissed.
Outright?
Outright.
Outright.
Or read-ins.
Are they read-ins or outright?
Read-in.
Read-in. All right. So,
joint recommendation is costs, time served.
2 days.
2 days.
Okay. So with regards to 25 or 15 CT 67, 15 TR 997, and 20 CT 47, as well as 26 CT 14, he understands all of those charges and those maximum penalties?
Yes.
And he waives formal reading?
Yes.
And at this time, not guilty pleas will be entered on his behalf. You would be entitled to a jury trial. You would be entitled to a speedy trial. What?
I think I interrupted you inappropriately. How's that?
I like that. Thank you. Accept that.
This is a crucial legal moment. Once a guilty plea is entered, rights are explained. The defendant gives up the right to a trial, which is a serious and final decision.
So you would be entitled, but you're going to be entering a plea here today, and you're going to be entering a plea in 26 CT 14, which is 1 count of operating while revoked. Is that correct, Mr. Glinke?
Yes.
I have in front of me a plea questionnaire waiver of rights form, all with other documents. Do you recognize those documents?
Yep.
Did your attorney go over those documents with you?
Yes.
Did he go over them essentially word for word?
Yes.
And you understand them completely?
Yes.
It looks like you have, you're 46, you have 11 years of schooling, you can read, write, you understand the English language, you understand those charges that the charge that you're pleading to, as well as the maximum penalties, no mental illnesses or disorders, no alcohol, medications, or drugs, correct?
Yes.
Because you're charged with crimes, you are entitled to constitutional rights, and each of those rights is listed on the first page of the plea questionnaire. Do you understand those rights?
Yes.
Your attorney thoroughly went over them with you.
Yes.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes.
Do you need me to go over those rights with you in any more detail?
No.
You understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
You understand that the state would have to prove on or around Friday, March 6, 2026, in Burnett County, Wisconsin, while being a person whose operating privileges have been revoked pursuant to Wisconsin law, you did operate a motor vehicle on a highway during such.
Here, the charge becomes clear: driving after license revocation. In legal terms, the key question is straightforward: did it happen or not?
Revocation period or thereafter. Do you understand what the state would have to prove?
Yes.
You understand the maximum possible penalty could be a fine of up to $2,500 or up to 1 year in the county jail or both.
Yes.
Do you understand that there is an agreement that's been reached between the parties that is that the court, a recommendation to the court for costs as well as for time served, 2 days of jail. Do you understand? I'm not bound to follow that.
Yes.
I said differently, I could sentence you to the maximum possible penalty. You understand that?
Yes.
Do you still wish to proceed and enter a guilty plea?
Yes.
Did you go over the criminal complaint with your attorney, and in particular that section called the probable cause section, where it basically says what happened that day and why you were charged with the crime?
Give us one moment.
Okay. Mr. Harrington is going to go over the criminal complaint one more time with Mr. Blinky.
License plate. Why they pulled you over. You were driving. You admitted you didn't have a driver's license. Vehicle belonged to who?
Oh, you don't. Or I can get.
Just bought it.
So,
Benjamin.
oh, she's not.
This is explanation. There weren't any drugs or alcohol or nothing in the car. You just driving without a driver's license. Any questions? Go ahead.
All right. So you understand the facts that are alleged?
Yes.
For the most part, are those facts accurate?
Yes.
Mr. Harrington, may the court use the probable cause section of the criminal complaint to find a factual basis?
Yes, Judge.
Has anyone made any threats or any promises to you for you to plead guilty to the charge?
No.
You're doing so freely and intelligently, telling the court you fully understand?
Yes.
And has your attorney represented you competently?
Yes.
Has he answered all of your questions?
Yes.
And has he looked at this matter thoroughly?
Yes.
You're satisfied with his services?
Yes.
Any questions for the court or for your attorney before I proceed?
No.
All right, then as to the sole count operating after revocation in 26 CT14, how do you wish to plead?
Guilty.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. The court will find you understand your constitutional rights and what it means to waive and give up your rights. We'll find a factual basis to accept your plea of guilt.
Now we move into the sentencing arguments. The prosecution highlights the defendant's history and repeated behavior, while the defense tries to frame this as a lower level.
Based on that, I will find you guilty of the sole count in the 26 case. The other matters will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. Argument, Mr. Schmidt.
These are OARs that occurred over a long period of time where he'd get it and then he'd just leave. That's why we have cases spanning back like a decade. You have Kenneth Cutt. The first one's a Kenneth Cutt's case. I think the time he's spent in his brief arrests, as well as the jail he sat the 2 days on March 9th and 10th, I think that's sufficient punishment. Thank you.
Mr. Harrington.
Thank you, Judge. Gravity of the offense, when I look at the operating after revocation, preface my comments with every crime is serious. But in the grand scheme of our criminal code, this is right near the bottom of seriousness. But it is serious because the law requires that people, if they're going to operate a motor vehicle on the public thoroughfare, that they have a driver's license, that they be subject to the state. Mr. Blinky has never had a driver's license. When you look at the criminal complaints, the factual basis, he's never had a driver's license. He had a OWI conviction long ago. He tells me he has some fines that need to be paid before he can get a driver's license. but that he's slowly but surely working on them. He's employed by his family, and
Is this his mom?
yes, she's his driver today. And he makes money and he pays cash and for most of his bills, and he's just kind of getting through life on a pretty low level. This appears to be a change in that the crime is the same, but he showed up today, and that's to his credit. When I talked to him yesterday, and then I changed and rechanged the hearing date from yesterday to today, that confusion was caused by me, not by Michael by any stretch. But I think this is an appropriate disposition. I looked at CCAP. He doesn't have a significant criminal record on CCAP, but it is what it is. So I urge that the court follow the recommendation and impose the fine and give him some time to pay and time served. Thank you, Judge.
Thank you. I usually don't do this, ma'am, but you did raise your hand, and I'm going to tell you, I have a question for you anyway. So what would you like me to know? Why did you raise your hand?
Because he's changing his life, from drugs and drinking and stuff.
Family member speaks. This brings emotion into the courtroom. Judges hear these kinds of stories often, but they still have to weigh emotion against the law.
And he's raising actually an 8-year-old grandchild of mine, and he's doing the teachers. I'm constantly checking in, and the teachers say he's doing fabulous. The kid is clean. The kid is always taken care of.
Just which child? Your grandchild or this kid?
The grandchild, that's what
My
she means.
grandchild.
I know she means the grandchild, but for the record, that's great to know. The 8-year-old, yes.
So he's really making steps to.
I appreciate that, and I'm going to have one question for you, and I'm hoping you're going to answer in the positive, because that's going to go a long way to him improving and stepping a lot further faster. But I'm going to wait. First, I want to hear from Mr. Glenke, and then I'm going to ask you a question. I'm really hoping in the bottom of my deepest of all my hearts that you're going to be able to do what I'm asking. Mr. Glenke, anything you want to let me know, you want to tell me? Your mom said a lot, and that was all good and positive.
Not much of a talker, but
That's fine. That's totally fine. Here's the deal. I know a lot of fines and fees are from me, not from me, but from my county, from here. I say me because this is me. And after today, there will be a total of $1,968 he owes. Here's what I'm willing to do. I'm willing to do this. I should have forfeited $500 a long time ago from 2020 when he failed to appear. But I'm going to tell you, I must have had a soft spot for him back then, because I'm like, no, I'm going to stay on whether or not I'm going to forfeit. Because again, I must have had a soft spot for some reason. So I didn't forfeit that. I still can today, right now, if I wish to do that. So if I don't forfeit, I have his $500 bail now, and I have that extra $500 I should have forfeited. So that means that I have $1,000.
This is somewhat unusual. Financial penalties are being adjusted live in court. The judge appears to be balancing punishment with giving the defendant a genuine chance to move forward.
If I'm able to get $225 today, I will waive the rest. And that's him getting his license a lot sooner. I need $225.
Yeah, I think I can do it.
You can do that today.
Yeah, I'll have to have money put into the account, but yes, I believe I can do that today.
Can you do it before you leave?
Yeah.
Okay, so if you can do that, then this is what I'm going to do. Because then Mr. Harrington, he'll be wiped out with me. Clean slate. So that means I'm not hindering his ability to get his license anymore. I don't know if he owes anywhere else, but at least with me, he'll be clean and free. All right. So what I'm going to do is I'm only going to assess the $200 DNA surcharge I'm required to do. I will waive the rest of the court costs and fees for today. I will take the 200 out of that, I will say the remaining 800 that I have in this case will be applied to past due fines and fees on the requirement that before you leave here today, you pay $225 to the clerk towards his fines and fees, and I will waive the rest. Deal? Deal. All right, done. So you should walk out of here with a clean slate. Don't drive in my county again without a driver's license, because I'm doing this for you. And it's for you, and it's for your 8-year-old. Okay?
Thank you.
20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I need your DNA. You're going to need to go to the jail and provide your DNA. This is something in which you can request the DNA be expunged through a written letter to the Department of Justice. If you fail to pay that $225 today, you're going to owe all of the money. I can issue a warrant and you could sit up to 6 months in jail.
This is the final warning stage, deadlines, DNA requirements, and consequences if the rules aren't followed. It marks the last step before the case is fully closed.
Okay, so hopefully we're going to have everything resolved and everything taken care of before you leave this building. It'll be paid, then you go to the jail, you provide your DNA. We're all good to go, Mr. Schmidt.
Nothing from me.
Mr. Harrington.
Thank you, Judge.
All right, then we are adjourned.
Tell the judge louder. Thank you.
Thank you, Judge.
If you go to the clerk, they'll give you the DNA form. We're out of time.
I'm glad to hear that you're doing all of these positive things, okay? Because I'm going to tell you, walking in here, I was going to take that $500 from back in 2020. But I heard great things. Don't let me down. Okay, I'm proud of you.